I remember the first time I filled out ATF Form 4473, the mandatory paperwork for buying a firearm. Between the boxes asking about felonies and domestic violence sits a deceptively simple question. Are you an unlawful user of or addicted to marijuana or any other controlled substance? Answer truthfully, and you lose your Second Amendment rights. Lie, and you commit a felony. This little checkbox is the mechanism by which the federal government still polices cannabis users. It springs from the Gun Control Act of 1968, which bars anyone who is an unlawful user of or addicted to any controlled substance from possessing a firearm. Back then, Congress aimed to keep guns out of the hands of heroin addicts and habitual drunkards. Half a century later, that same language ensnares people who use state-legal medical marijuana. Today, cannabis is legal for some purpose in a majority of states, and millions of Americans use it medicinally or recreationally without harming anyone. Yet, marijuana remains a Schedule I substance under federal law, defined as having a high potential for abuse and no accepted medical use. This classification is increasingly out of step with reality, but until the Drug Enforcement Administration finalizes its proposal to reclassify marijuana to Schedule III, federal law treats cannabis like heroin. As a result, the Bureau of Alcohol, Tobacco, Firearms, and Explosives, ATF, instructs gun dealers to deny sales to anyone who admits to using cannabis. Patients with PTSD, cancer survivors managing nausea, or adults enjoying a joint after work all face an impossible choice: keep their medicine or keep their guns. In 2025, that conflict reached the U.S. Supreme Court in United States v. Hemani, a case challenging the constitutionality of the gun ban for marijuana users. Around the country, federal courts have issued conflicting rulings on whether the ban survives the court's recent Bruen decision, which requires modern gun regulations to be consistent with historical tradition. The issue is no longer academic. Millions of Americans' rights hang in the balance, and even the Trump administration's Justice Department has asked for extra time to prepare its arguments. In this video, I'll explore how we got here, what the courts are saying, and what the Supreme Court's upcoming decision could mean for cannabis users and gun owners alike. The idea of disarming drug users was inserted into federal law in 1968 when Congress feared that addicts and drunkards were threats to public safety. Section 922G3 prohibits anyone who is an unlawful user of or addicted to any controlled substance from possessing a firearm. Marijuana later became a Schedule I drug, defined as having no accepted medical use and a high potential for abuse. Even though dozens of states now permit medical or adult use, the federal classification has not changed, so the Bureau of Alcohol, Tobacco, Firearms, and Explosives treats all cannabis users as unlawful. Regulations deem someone an unlawful user if they have consumed a controlled substance recently. Form 4473 warns that marijuana remains illegal under federal law, even if state law says otherwise. The result is a catch-22. Honest patients who answer yes on the form are denied firearms, while those who answer no commit perjury. There is no similar question about alcohol or prescription drugs.
At its core, the controlled substances definition was meant to address heroin and hard narcotics, not a plant that many now use for arthritis or anxiety. The Controlled Substances Act created 5 schedules. Schedule I drugs are considered highly addictive with no recognized medical benefit. Placing cannabis in that category was controversial even in 1970, and opposition has only grown. In August 2023, the Department of Health and Human Services recommended moving marijuana to Schedule III, acknowledging its medical use and lower abuse potential. Yet, until the DEA formally enacts that recommendation, the law remains unchanged and the ATF continues to treat marijuana like heroin. This disconnect between federal classification and state policy highlights how outdated the statute is. Patients who buy cannabis from a licensed dispensary and pay state taxes are still labeled unlawful users under federal law. The policy punishes honesty and discourages people from disclosing their medical treatment to gun dealers or even their doctors, exacerbating distrust in the legal system. After the Supreme Court's 2022 decision in New York State Rifle and Pistol Association v. Bruen, which requires gun regulations to be grounded in historical tradition, challenges to Section 922G3 proliferated. Appeals courts split on whether the ban could survive. The Fifth Circuit struck down a conviction because it found no historical analog for disarming someone based solely on nonviolent marijuana use. The Third, Eighth, and Sixth Circuits similarly held that the government must prove a particular user is dangerous before stripping away gun rights. When the 11th Circuit reviewed a case brought by Florida medical patients, it rejected comparisons between marijuana users and habitual drunkards and sent the case back for fact-finding, reasoning that law-abiding patients cannot automatically be deemed dangerous. These rulings create a patchwork. In some parts of the country, marijuana users cannot be prosecuted under Section 922G3, while in others the ban remains intact. The split paved the way for Supreme Court review. Each circuit's reasoning illuminates how judges are grappling with the Bruen framework. The Fifth Circuit's opinion in United States v. Daniels emphasized that there was no founding-era tradition of disarming people for private drug use, and noted that the defendant belonged to the political community. The Third Circuit's decision in United States v. Harris allowed the statute to apply only if the government could show the defendant posed a special danger, a standard borrowed from laws targeting those who were intoxicated while armed. The Eighth Circuit in United States v. Cooper and the Sixth Circuit in United States v. Van Octen both required prosecutors to demonstrate an actual threat. By contrast, districts outside these circuits continue to uphold the ban as a categorical rule, leaving citizens uncertain about their rights. The 11th Circuit's opinion is particularly noteworthy because it joined the Fifth in vacating a dismissal and demanded evidence that medical users are dangerous. That court also pointed out that the DEA's proposal to reschedule marijuana could affect the analysis, suggesting that even judges are sensitive to policy changes.
The dispute now before the court centers on Ali Danyal Hemani. When agents searched his home, they found a handgun, about 60 grams of marijuana, and a small quantity of cocaine. Hemani admitted to habitual cannabis use, but was not charged with drug possession. Instead, he was indicted under Section 922G3. A district court dismissed the charge, and the government appealed. Solicitor General D. John Sauer argued that the law is akin to historic bans on habitual drunkards and serves to prevent dangerous behavior. In October 2025, the Supreme Court agreed to hear the case. The justices must decide whether the Constitution permits a blanket prohibition on firearm ownership by marijuana users, including those whose use is legal under state law and unrelated to violence. The case's outcome could either entrench the current ban or force regulators to craft new, more targeted restrictions. Recognizing the stakes, the Justice Department sought extra time to prepare its arguments. Hemani's case is also notable because it combines two controlled substances. The presence of cocaine complicates the narrative. While Hemani admitted he was a habitual cannabis user, the government's petition stresses his possession of both drugs as evidence that drug users pose a broader danger. Advocates worry that the court might conflate marijuana with harder substances. The Solicitor General's brief argues that Section 922G3 imposes only a temporary burden. Users can simply stop using drugs to regain their rights. Opponents counter that this is unrealistic for patients who depend on medical cannabis and that there is no way to pause a treatment regimen without suffering. The court's analysis will hinge on whether historical analogs exist for such a blanket disqualification and how closely modern laws must match those analogs under Bruen. The case will also test the limits of originalism. Will the justices rely on 18th century laws that targeted drunkards and dangerous lunatics, or will they recognize that cannabis occupies a different cultural space in 2025? The abstract legal fight has tangible consequences. Florida plaintiffs Vera Cooper and Nicole Hansel lost the ability to purchase firearms after they truthfully disclosed their medical marijuana use. Retired police officer Neil Franklin wants to use medical marijuana but worries that doing so will label him a criminal. Elsewhere, the ATF has warned Kentucky residents that enrolling in the state's medical program will disqualify them from owning guns. Legislatures in Pennsylvania and Colorado have pursued reforms to protect cannabis patients, and Kentucky lawmakers passed a resolution urging Congress to amend federal law. These state-level efforts illustrate growing discomfort with federal policy and highlight that real people are trapped between conflicting laws. For many gun owners, the cannabis question is not theoretical. I've spoken with veterans who rely on marijuana to treat PTSD, but cannot legally purchase a firearm for home defense. One told me he felt betrayed by a government that asked him to serve his country, yet refuses to trust him with his own safety once he returned home. Others simply avoid medical registries altogether, paying cash at dispensaries to keep their names off lists. Advocacy groups like National Organization for the Reform of Marijuana Laws, or NORML, and the American Civil Liberties Union have joined lawsuits or filed amicus briefs supporting plaintiffs. At the grassroots level, some gun stores in legal states warn customers not to mention cannabis on Form 4473. These anecdotes illustrate the law's chilling effect and the everyday compromises people make to navigate a patchwork of regulations.
Critics argue that the ban is hypocritical. Alcohol, a far more violence-associated drug, does not prevent gun ownership, yet cannabis does. Early American regulations punished those who were drunk and disorderly but did not permanently disarm drinkers. The Justice Department's reliance on colonial laws disarming Catholics and Loyalists to justify the modern ban has drawn ridicule and been rejected by several courts. At the same time, the DEA's proposal to move marijuana to Schedule III undermines the premise that cannabis users are uniquely dangerous. Rescheduling would acknowledge the drug's medical value and raise questions about why alcohol and prescription drugs are treated differently. Some lawmakers have floated ideas to narrow the statute, such as exempting state legal use or limiting the ban to gun possession while impaired. But Congress has yet to act. It's worth remembering that 18th and 19th century regulations targeted specific conduct, not categories of people. Towns fined those who fired guns while intoxicated on holidays. Early militias sometimes required sober training. They did not impose lifetime bans on all who consumed alcohol. This distinction matters under Bruen's historical test. An analog aimed at drunken revelry cannot justify permanently disarming a cancer patient who uses cannabis oil at home. Even within federal law, contradictions abound. People who abuse prescription opioids, also controlled substances, are not singled out on Form 4473. And while the ATF warns cannabis users of potential penalties, it does not notify gun owners that drinking to excess could jeopardize their rights. These inconsistencies make the current policy appear less about safety and more about lingering stigma toward marijuana. From my perspective, Hemani is more than a gun case. It is a test of whether federal law can adapt to shifting cultural norms. I support keeping firearms out of the hands of violent criminals and those impaired at the moment they handle a gun. But I cannot justify a rule that treats a veteran using cannabis to treat PTSD the same as a cocaine dealer. The circuit court's decisions reflect a growing judicial recognition that laws must target dangerous conduct, not status. Whether the Supreme Court agrees remains to be seen. If the justices strike down Section 922G3 as applied to marijuana users, Congress may finally feel compelled to rewrite the statute. If they uphold it, pressure will mount at the legislative level to harmonize federal gun laws with modern cannabis policy. In either scenario, citizens should stay informed, engage in advocacy, and consult legal counsel before navigating the minefield created by Form 4473. The conversation about guns and cannabis will continue, and the principles at stake, honesty, fairness, and constitutional consistency, are worth fighting for.
We are at a pivotal moment where the arcane intersection of drug policy and gun rights has become a national controversy. A law written in 1968 to disarm addicts now forces cancer patients and veterans to choose between pain relief and self-defense. The Supreme Court's originalist pivot in Bruen prompted a cascade of litigation, leading the 5th, 3rd, 8th, 6th, and 11th Circuits to cast doubt on the constitutionality of Section 922G3 as applied to marijuana users. The Department of Justice under President Trump insists that habitual drug users pose unique dangers and wants to preserve the ban, but lower courts are unconvinced. The Supreme Court's decision to hear United States v. Hemani means the 9 justices will soon decide whether marijuana users can be constitutionally disarmed. Regardless of the outcome, the case highlights broader issues. First, there is the glaring mismatch between federal and state cannabis laws. When half of the states legalize a substance that the federal government still treats as contraband, conflicts are inevitable. Second, the case underscores the dangers of using historical prejudice as a justification for modern restrictions. Citing colonial bans on Catholics and Loyalists to disarm cannabis patients reveals the poverty of the government's historical evidence. Third, the debate illustrates how the war on drugs continues to influence unrelated areas of law. Even as support for legalization grows, federal policies can still punish users in unexpected ways. If the Supreme Court upholds the ban, expect calls for legislative reform. Lawmakers may be forced to clarify the statute, carve out exceptions, or adopt more targeted approaches. If the court strikes the law down, regulators will scramble to craft new rules that address impairment without criminalizing millions of citizens. Either way, the conversation is far from over. Rescheduling, state legislation, and shifting public opinion will continue to shape this area of law. For those directly affected, the case is about more than abstract constitutional principles. It's about being able to alleviate pain, treat PTSD, or unwind legally without forfeiting your right to defend yourself. As a lawyer and citizen, I believe that laws should punish dangerous conduct, not peaceful behavior. The Supreme Court has an opportunity to align federal gun policy with modern realities and constitutional values. Whether it takes that opportunity will tell us much about the direction of the court and the future of cannabis reform. Stay tuned.